And taking you back to our story now with a new development, the Pretoria High Court was all set to deliver its judgment in the Gordhan versus Oakbay case. Gordhan had approached the court as finance minister to declare that he cannot interfere in a bank-client relationship. The issue pertains to Oakbay accounts being closed by several banks. Oakbay has called Gordhan's application moot as they have never questioned the powers of the minister. At the last hearing, the court had chucked out the FIC report listing 72 so-called suspicious transactions attached to Gordhan's plea. Agreeing with Oakbay's argument, the court said that the FIC certificate was irrelevant to the case. Good morning. We have one of our assignment editors, Miss Cecilia. Cecilia, good morning to you. Take us through the breaking news right now that the case between Gordhan and Oakbay has in fact been struck out.
No, it hasn't been struck off. Gordhan has lost the case. He's lost his application to have a declaratory order saying that he should not interfere between a bank and the client's relationship. This is an extraordinarily important decision that the court has made, because the only principle that was left for them to decide on was a constitutional principle which would have meant that under no circumstances in any case would a bank, would a minister or minister be able to interfere in any way between the bank and the client forever, you know, for the future. Mm-hmm. This would have been a very, very bad in law, because it would have tied ministers to a particular course of action, and it would not have been in the court's interest for them to. It would not have been in the interest of government to have nobody able to lobby ministers, etc., in the future. Mm-hmm. So this is a very significant victory for the Oakbay group, in that. A couple of things happened during the court hearings that was very important. One is that when Gordhan brought this application, he had FI certificate. Mm-hmm.
Now, Cecilia, beyond this now, for Oakbay, you may say this is a precedent-setting case, but beyond this, does Oakbay plan to do anything else?
Well, Oakbay is at the moment in some litigation around banking, which will be clarified later. So they are taking action, and obviously they are trying to ensure that their businesses continue to work. But their particular role and the work that they're doing, you would need to get a spokesperson from the company themselves to explain exactly the future. I can talk about the legal implications of this particular case.
No, I hear you, Cecilia. It's certainly a story that we'll be talking about throughout the whole day, if not days to come. But thank you very much for talking to us. That remains our breaking story there on Oakbay, where the Pretoria High Court was set to deliver the news on the case of Gordhan versus the Oakbay. They have dismissed the request to strike out the Oakbay, and they've granted the application and shall incur costs. You'd remember that Gordhan had approached the court as finance minister to declare that he cannot interfere in a client or in a bank-client relationship. The issue pertains to Oakbay accounts being closed by several banks. Oakbay has called Gordhan's application moot as they have never questioned the powers of the minister. So today, at the very least, that plea was dismissed. At the last hearing, some would remember that the court had chucked the FIC report, which listed 72 so-called suspicious transactions attached to Gordhan's plea, and agreeing with Oakbay's arguments that the court said the FIC certificate was irrelevant to that case. It remains our breaking news. We'll continue to speak to a number of people on the story, as it remains a precedent-setting case, especially for most ministers, as to the powers that they have. Can they intervene? Can they not intervene? So it will remain one of the talking points throughout this day. We have our special assignments editor back on the line. Cecilia, more news on the story. We seem to have lost Cecilia, but we certainly will get her back as We continue to unpack this story from the Pretoria High Court, where they delivered a judgment in the Pravin Gordhan versus Oakbay case. Gordhan had approached the court as finance minister to declare that he cannot interfere in a bank-client relationship. We seem to have Cecilia back on the line. Cecilia, more on this story, just in layman's terms, to break down for the ordinary citizen, what does this judgment mean?
In ordinary terms, it means that a minister, the minister wanted to ensure that he would never be asked to interfere in a bank-client relationship. It means that it means actually that if necessary, if it is required, he would be able to interfere, or he could be lobbied to perhaps ask the banks, why they're taking a particular course of action. Mm-hmm. What he wanted was a declaratory order which said that he could never interfere with his with the bank-client relationship. This is patent nonsense because, for example, any institution, any banking institution, any business institution, or what have you, if, for example, they are involved in something illegal, it would be
they need to be regulated. There must be accounts.
Unprecedented for a finance minister not to say to the bank, "You cannot behave in this way. It is clearly going against our constitution, etc., etc." So, but this is a very, very long and acrimonious fight that the former finance minister Pravin Gordhan had with members of the Oakbay family. And if you ever look at his original affidavit to the court, he had attached an FIC certificate, and and the implication by attaching that FIC certificate was that the Oakbay group was involved in wrongdoing. The Gupta family and the whole controversy that they were involved in wrongdoing. So when they threw out that FIC certificate and said that it was irrelevant, and in actual fact the Oakbay company went to try and analyze all of those transactions on it and could not even identify a lot of them, but most of them were the ones that they could identify were completely regular transactions. When they threw that out, they threw out the concept that a organization or families who were potentially perhaps corrupt were in actual fact that he was not acting on behalf of.
Very interesting is that the Oakbay group themselves seemed to be quick to say, no, we've never questioned the powers of the minister. We don't believe that he needs to intervene. Only for them here, if they humbly thought that, no, he doesn't have to intervene, today it's found out that there are times where you might need to intervene as a minister.
Yes, he may need to intervene as a minister. They never said that they had insisted that he intervened. They had lobbied him. Now let's just talk about lobbying in government. I mean, we've just come out of Marikana. There was a letter that Ramaphosa wrote to various very high-ranking officials and ministers during the London. He was lobbying them to do something about this is what he's saying. He was lobbying them to do something about the situation in London. Ministers get lobbied all the time by all sorts of people. And so when the banks were closed, the Oakbay group went ahead and tried to lobby a whole variety of people. They went to SARB, they went to the Treasury, they went to the banking, ombudsman. They went all over the place, the banks themselves, etc., to try and resolve this thing. And this is what they were doing. They were lobbying. The minister, for some reason or another, believed that this was that they were pressurizing him and forcing him to act, and that was not the case. But this particular precedent is important because it means that an ordinary, no minister in future will be constrained by a declaratory order.
Now, Cecilia, if you can just remain on the line, we just want to have Mzwanele Manyi join our conversation, PPF President. Mr. Manyi, very good morning to you. What do you make of this judgment today?
Yeah, good morning to you and your viewers. Look, I think firstly we must applaud the justice system of this country for always being impartial and for always ensuring that the rule of law and not public sentiment wins the day. This was a very difficult case, and I really think that the country's interest has been at the center of this. Picture a situation where an international player wants to come into the country, and that international player has got no recourse whatsoever to even ask government to say something when something wrong is happening in their business. What this case is saying is that we cannot have a situation in this country where private sector becomes the judge, the jury, and the executioner all by itself without involving the justice system. So indeed, I think the rule of law has been upheld by this judgment. And by the way, I think that it was also very frivolous for the former Finance Minister, Private Gordhan, despite advice by a very high-powered senior counsel, Gauntlet, to say to him that there's absolutely nothing that forces him to do anything. So this was clear even from the beginning that he had no case to go and ask the court to confirm what a highly seasoned lawyer like Gauntlet had already told him. So indeed, if you look at the fact that the court is saying he must pay the cost, I really think he should really indeed pay the cost, and I hope the costs are even personal, so that people that are operating on the public purse must be a bit more circumspect when they deal with the public funds. We cannot have a situation where the monies of the taxpayers are abused by people that are busy with various nefarious agendas and with various activities just to boost their own egos. So indeed, for us as Progressive Professionals Forum, we indeed salute this judgment. We think this judgment is consistent with our constitution. We think this judgment upholds the rule of law.
But beyond this, because I think it would be just unfortunate to confine ourselves to the legal aspects of this case, do you think there was any political conspiracy behind all of this here, where there was political meddling or some sort of bigger agenda?
Look, in South Africa today, you cannot rule out the issues of regime change. So it could very well be that this was a far bigger thing to be able to cripple, to constrain, and to contain the economy of South Africa to the bigger powers that be. So indeed, we continue to celebrate our independent judiciary, that our judiciary must have seen through all of this, that we can't have a situation where this was a serious state capture, where you have a private sector that says, government, you cannot do anything. If we are doing our things, stay on the side. I mean, that is a real arrogance of the private sector that the court has managed to nip in the bud. So we really hope that going forward, this should give impetus for people to challenge these draconian decisions that some of these banks take on individuals that haven't got the wherewithal to fight their cases. We are fortunate that we have people like the Guptas that had the resources to be able to fight this case. Anybody else would have just been dealt with, and that would have been the end of the story.
And that's the unfortunate part. That remains the unfortunate part, because you talk of resources, that even if you want to challenge any application that's brought against you, it remains a money's issue. That if you do not have the resources, then you allow anything to be done to you in South Africa. Exactly.
That is exactly the challenge, and we hope that going forward, our justice system in the country should be accessible to the poorest of the poor. Right now, the justice is only enjoyed by those that can afford it, which is a very unfortunate situation. So for us as Progressive Professionals Forum, we'll be making submissions to government to say, how can we arrange a situation where the justice cannot be just a privilege of the money.
No, Mr. Manyi, thank you very much for joining us. We're still discussing the Pretoria High Court's ruling from today, just a few minutes ago,